Artificial Intelligence, Law and Justice course, Session 33, AI and Human Rights. As usual, we will do a recap of the previous session. In the last session, we discussed how AI will impact the roles and functioning of judges and looked for whether the current guidelines are adequate enough. Further, we discussed the whole idea of humans in the loop, particularly when we applied this to judiciary. Moreover, we stressed the need for capacity building, more use of the expandable AI in the judiciary. So, we did review how AI is likely to impact the functioning of the judges, and then what sorts of new skills, new level of capacity building is required among the judges to come to grips with the developments in AI. In this session, we will be dealing with an important topic on AI, that is AI and human rights. Although this topic is not much discussed in the literature or often discussed as a specialized topic, this is equally important because we can easily connect that previous sessions like expandable AI, algorithmic accountability, and also with some of the things related to algorithmic decision making and how AI made decisions are affecting the rights and the entitlements of people. So to begin with, what are the major issues in human rights and ethical challenge of AI? First of all, AI can be used for a deliberate use, a deliberate misuse to suppression. In the sense that for mass surveillance, limiting freedom of expression, then also monitoring public compliance with behavior rules. Because AI is a technology that can be implemented as part of the many surveillance technologies, including facial recognition, including gathering of information of various people's social media use and then behavior online through different tools, and then also through spyware and other technologies. Moreover, the collateral consequence of AI's operations are that AI can exaggerate the bias and discrimination, can create them anew. The question of privacy relating to AI, particularly the question of personal privacy, is also equally important. So AI can harm personal privacy or can restrain its personal privacy directly or indirectly. And then, of course, in the case of certain things like healthcare and welfare, although AI per se may not be the ones that should be blamed, AI-based systems can impact the human rights and the entitlements of many people. Then the different outputs of AI can be manufactured or can be manipulated to suit audience views, in the sense that giving disinformation, misinformation, creating deep fakes and all, and thereby ensuring that they do not fully exercise their freedom of expression and violating their freedom of thought. So when AI can be used to prioritize contents that include hate and incite violence, these are some of the human rights issues that we need to come to understanding as to why AI is something like a double-edged sword. So what is happening is that often the governance of AI, principles like transparency, accountability are mentioned, and even ethics is also brought in as a key theme. But then human rights is not that given that much importance. So there is a need to look into the issues and challenges in AI governance from a human rights lens. Then there are lots of myths about human rights, in the sense that human rights are often talked about only by specific people. Human rights need not be something that should be really taken into account because there are other things like expandable AI, responsible AI, those can take care of all those things. And then there are myths about human rights themselves, that human rights are not necessary for a well-being of the society, or they could be misused, or those who talk of human rights are often end up supporting causes that are not lawfully correct. But human rights has to offer a lot to AI because as a fundamental right, human rights covers a whole lot of things. And in the Indian context, Indian Constitution protects and guarantees human rights through various articles in the Constitution. So, if we look at governing of AI from a human rights perspective, we would find that there are a lot of things where human rights concerns about AI can be expressed and explored. There are three dimensions of AI governance which we need to take into account when we talk of UI. First, there should be substantive standards for AI development implementers to ensure that these standards which meet the minimum human rights standards are met. And then accountabilities and remedies for breach of human rights are also incorporated to that. So first idea would be to integrate or bring in the human rights law or at least the human rights articles into the AI governance principles, which means that going beyond transparency and accountability, bring the fundamental core human rights into as a core governance values in AI. Then AI system should be assessed in terms of AI ethics. AI ethical risk assessment should also include human rights values over there. Particularly when it comes to data governance, we should look at the privacy angle. We should look at some of the other related things like whether data governance norms can be used or misused not only to violate privacy but also to spread false information. Then, automated decision making, when they are assessed through human rights lens, certain things will be very clear to us. For example, the Canadian directive on automated decision making brings in a human rights perspective to that. Similarly, in the USA, there's a draft act on algorithmic accountability that has got a human rights dimension to that. So, the ethical risk assessment of AI can benefit a lot if human rights are also made part of that. On the other hand, it is necessary, if not down outright, to claim so, that some forms of AI or some systems of AI with specific innovations should not be developed at all or they should be prohibited. For example, AI systems that can come up with serious ethical concerns, the sense that can spread malware, they can tamper with other systems or they could be used for malicious purposes, they should be banned. But the prohibition, there is lack of consistency because there is lack of measurement. And then there are a lot of dual use concerns with AI because it could be used for good purpose, not for some bad purpose. Dual use is there where we know that certain dangers can occur on account of use of certain technologies. And then rationale behind specific provisions are not explicitly acknowledged, but then they should be made transparent. For example, in some US states, facial recognition technology has been banned, if not fully, some of the uses. Then the AI Act has got detailed explanation on using AI for manipulating human behavior, human consumers, and more importantly, biometric identification is heavily ruled or heavily regulated through AI Act. Of course, AI Act also does a whole lot of risk analysis, also looks into various potential harms that could arise on account of AI, and more importantly, has got a human rights dimension built into it. So, some sort of prohibition of certain AI forms. For example, in the recent days, there have been a lot of demands to ban deepfakes and then AI systems or AI related misinformation, disinformation. But then these are not only legally challenging, but also there are a lot of definitional issues as to how do we define them, and more importantly, are there any available technical means that could be used to prohibit them right from the beginning. But that again is a very ticklish issue because defining them itself is a big problem. Technical issues can be overcome, but with those with malicious intentions often find ways and means to really overcome some of these barriers. Then the need for transparency measures in AI is which we have talked about again and again. But algorithmic audits should also look into the potential human rights violation that can happen when algorithmic decision making is unchecked. The Digital Republic Act of France, for example, mentions about maintaining of registers and release of source code or algorithmic audit for as a public transparency measure. UK government launched an algorithmic transparency standard in November 2021. These, when implemented, also take into account some of the human rights concerns that arise when AI systems are deployed massively. Government by default and by their own statute and then by their own constitutional undertaking are bound to honor the human rights. And there can be no exception to AI on this ground. So governments have to ensure that AI usage in public decision making respects human rights and does not violate them either in part or in full. Moreover, it is also equally important that AI is not to abuse human rights or AI is not to promote human right abuses. So it is important that non-state actors and the private companies are not using AI for the purpose of human right abuse. Then there are state obligations under various constitutional provisions as well as the state's obligation under different international covenants, treaties and agreements to protect human rights. So those should be fully adhered to when we talk of AI systems. Now the government's duty to protect can come in different forms. It can come in national mandatory institutional forms. It can come through by setting up specific institutions like human rights commissions or human rights ombudsmen or human rights agencies to monitor and then to come to a conclusion by examining specific cases when complaints are brought to it. And some of these measures can be voluntary, but some of them can be mandatory. And then there is also a business respect for human rights. Often business have some compact or business come up with voluntary guidelines to respect human rights, partially on account of the initiative by UN to bring together the business entities or the corporations as well as the human rights activists to come to an understanding on how business can adopt human rights and thereby contribute to societal good. But then state can take much more than that, particularly when they bring in AI systems into public use or when they largely display and deploy AI for a larger purposes. There are two things which we need to be very clear about. The obligations of the states under the different conventions, treaties, or covenants or protocols does not hinge upon how AI is going to develop or how AI has developed. It is independent of that. Or government should not wait and then see as to how AI will harm human rights. Rather, they should take a proactive steps to ensure that harms are eliminated or if not eliminated, fully minimized. The second point here is that compliance with human rights and then promoting innovation in AI should not be seen as opposites. They should go hand in hand, or only innovations that promote and respect human rights should be given importance. So the governance perspective in human rights when it comes to AI should be with a proactive engagement rather than a reactive or something which happens after some other damage has been done. So we would need lot of actions from the governments either through impact assessments or set up specific mechanisms and institutions to probe potential and actual human rights violations and also to do them on a continuous basis. And capacity building here is very important. And more importantly, technology should be audited for their potential human rights violation or for potential human right harm. It is also possible that technology can be used to promote, harness, and then fully utilize human rights. So, when it comes to compliance with human rights, government should also give importance, promote, incentivize development of technologies that can further the cause of human rights. So, what we need? We need a smart, good mix of laws and policies to promote human rights and ensure that AI does not end up in violating or negating human rights. So it should start with companies. It can be voluntary code, or it could be something like companies come together, or it could be through different legal means or different acts or binding commitments. Then some of the ethical commitments should be very clear that there is no ambiguity in them or they are very transparent and the sense that they are binding, very clearly binding, and there can be no way of treating them or reading them or misreading them in two or three more ways to say that this does not mean that this, or an ambiguity in that should be avoided. Then comes how the state should take into account. As if we said, they can enact specific acts to deal with AI related human rights violations and harms and establish specific mechanisms or integrated that into the current mechanisms. But states are also obligated, particularly under the EU Act, to prohibit certain risky AI applications because they could be violation of human rights. Similarly, different states, different countries will have governance norms to regulate certain risky technologies or risky innovations. Some specific applications like biometric technologies or use of genetic evidence or some of the technologies that would be used for surveillance, when viewed from a human rights perspective, could be either negated in the sense that banned or very strictly regulated in the sense that their use is allowed only when there are specific contexts and when there is a specific need to use them. Often the courts decide as to under what context some of these tools can be used and then who will be the one who will be supervising it. So to begin with, there's an urgent need for integrating human rights into regulation. Rigorous rights, standards and due process should be brought in first, and then do a human rights audit or impact of human rights assessment to the AI innovations where there's a good potential for violation. Then while assessment of human rights should be made explicit, this is not something that should be done stealthily or hidden. It should be something very concrete, very prominent. And then also incentivize corporates through good practices, give them some incentivize, and then show that they demonstrate full respect for human rights in letter and spirit. And public reporting on account of algorithms, on account of AI innovation should be made mandatory. For example, as we said, the French Digital Act also mandates certain measures like that. Companies, as part of their due diligence report, should mention that whether the AI systems they bought or they have acquired or they have put into place are fully compliant with human rights or do they violate human rights. And more importantly, human rights impact should be assessed, addressed, and then ensure that human rights impacts negatively are not the innovations that are permissible. And systematic AI audit should be, and the audit process should be made part of the regular AI audit. To make these things happen, there should be a clear-cut legal liability and the responsibility to do them. And then this should be supervised by an institution either set up by the state or by the higher judiciary or as a combination or as an autonomous organization. So the systematic AI audit or algorithmic auditing of algorithms and then the audit processes should be an ongoing regular routine practice. Then of course supervision accountability, we should say it should be built in as a process of that. Then more importantly, often what happens, governments are the major buyers of the AI systems in the market. They also commission AI systems through innovation, in the sense that they are the ones who buy, they are the ones who commission. So when the government procurement obligations are there, the government should ensure that AI human rights audit is made part of that. So the implication of AI system in terms of human rights should be made upfront and then should be made available. And then AI meets the minimum standards of human right in terms of equality, non-violation of privacy and other rights should be mentioned. Or in other words, government should not go for AI systems that prima facie and upfront violate equality and then privacy and other fundamental rights. This we have seen earlier also when we talked about transparency and accountability, more from an algorithmic responsibility perspective. And then when governments enter into public partnership, private partnerships or similar initiatives, ensure that wherever AI is deployed, human rights are not violated. More importantly, government should ensure that public procurement systems enhance human rights standards in AI industry or incorporate the minimum human rights standards when they are developed. So the compliance of the adopted system should be regularly reviewed and there should be annual review of various systems where there is a potential of harm or abuse of human rights can happen. UN has come up with a compact for business and human rights. This compact has got some guiding principles respecting for human rights, policy commitment, due diligence process, and benefits of responsible business agenda. So when the private businesses adhere to this compact or adhere to the UN norms, they should ensure that AI does not result in human rights violation. But then there are a whole lot of issues in the sense that these are easy to talk of and then easy to even say that this should be done, that should be done, this is what should be mandated. But in real practice, translating them into actionable points or actionable agenda items is not all that simple. Why? AI is not a dumb system. AI is not a blind system. AI systems are often have the capacity to learn, capacity to be flexible, adapt and adopt. So when they have the capacity to have self-improvement, learning and then putting that into practice in a loop, it is very difficult to predict what exactly the consequences will be. However much the initial assessments would have said that no violation of human rights would be possible. This is all the more true when we talk of bias, discrimination and then violation of equality. Then identifying the specific human rights violation also depends upon the technology, type of use, and then what sort of uses are being envisaged, and then what sort of uses the system is actually put into practice. So the excessive due diligence should be part of that, and it should involve wide stakeholders. This is not something where the company is given a form to fill and then tick the boxes. It should be much more serious and sensitive to that. More importantly, the regular review of AI systems, however cumbersome, however time consuming it is, should be done from a human rights perspective. So the problem is also there because not many companies even today have a regular AI governance structure in place where some of these things can be incorporated so that they fit well within the AI governance framework. On the other hand, due diligence often ignores some of the critical AI related matters in the sense that what the stock market authorities need, what the government authorities need, or what different regulators need often will not have the AI human rights impact assessment as part of that. So some of these gaps should be assessed by the regulators as well as by the government. Then there are lots and lots of good corporate AI audit or AI assessment, AI impact assessments, which are called as AIAs. For example, AIAs are labeled as human rights assessment as well. Verizon has got an ongoing human rights due diligence where Verizon itself undertakes that as on a voluntary basis. IEEE's adopted AI ethics assessment has brought in human rights due diligence as part of it. Similarly, Google's deployment of AI reinforces AI principles, references, and includes consultations with human rights experts. These are just some examples because many of the bigger corporates, particularly the multinationals, are very sensitive to accusations on human rights violations, particularly bias, discrimination, and then gender discrimination. So they are trying to ensure that their corporate names are not spoiled or their corporate image is not spoiled on account of something going wrong when AI violates human rights. So they're on their own incorporating or building up tools that facilitate corporate AI audits. Generally, pro-human rights culture should be brought in because taking human rights as yet another item to be taken or something that is of not much importance to the business is not the right attitude. So the due diligence process should bring in the human rights angle, and then the intentions and activities related to human rights are publicly available, and then companies themselves should make it available to their own employees because nobody should think that this is something that is an option that can be ignored. So as we said, there are multiple remedies available in AI governance. Specific issues need specific action points, whether it is bias or privacy. Of course, there are a lot of laws which cover them, but then taking a holistic perspective, there could be gaps in that. So AI human rights perspective will be able to address them and then fill them. Then human rights are not one or two. Core human rights defined in the constitution could be important, but then there are other human rights which the governments would like to emphasize and enforce upon, so they should be brought into the picture. But often what happens, the impact assessments are done as a routine matters. What they stated in them is not taken further to revise the AI systems, and then they remain as yet another ticking the boxes. So this practice should stop. And then the human rights risks need mitigation strategies, but impact assessments do not advise any mitigation strategies or do not recommend any mitigation strategies. They stop short of that. They simply say that there's a potential human rights violation or there has been a human rights violation. Then the business practices balances risk and benefit. Often human rights are not given that importance. So compared to the benefits, this is a risk that we can afford to ignore, or we need not pay undue adherence or attention to that. That's the normal perspective. They should undergo change. More importantly, what happens when AI violates human rights, particularly on account of failures of AI to do something positive, or by default the system did something that was totally unanticipated in the nature, in the sense that unanticipated consequence. So what should be done should be clear-cut corporate policy on these things. So how do we prevent them? Further, it should also be part of the corporate larger strategy on AI and human rights. Now, we have seen lot of to do things, do this, do that, this is good, this is how it should be, but we will also look into some cases where courts and other institutions have taken a lead in identifying certain things for human rights violations and have dealt with them. Finland's National Non-Discrimination Equality Tribunal in March 2018 gave a ruling against a credit institution because the credit decision was based on assumption from a statistical data, and then the criteria included gender, first language, age, and residential area. These discriminations we have already discussed in detail in the previous classes. So the tribunal said discrimination was there, decision was discriminatory, and it said that such decision-making tools or methods should not be used in future. In Hague, there was a system which was used in Siri by the government. And the idea is to review the personal data for predict benefit or loan fraud, tax fraud. But then the government did not share adequate details about as to how it was used. So individuals who are impacted by that found it very difficult to challenge. They felt their privacy rights have been violated by Siri, and then was not in line with the Article 8 of European Charter for Human Rights. So they went to the court, and then government said Siri was used only in specific neighborhoods that were classified as problem neighborhoods, and then the proxy for discrimination based on socioeconomic background and immigration status. So they used certain things as a proxy, and this was found to be totally wrong. In South Wales, police trialed automated facial technology. They put that into automated facial technology, in the sense that as you move, as you go, as you walk, as you do run, or as you drive a vehicle, your face will be automatically tracked. And then they compared the public CCTV event attendance with the database which they earlier had. And then they also looked into the non-matching items. Oh, this place is not found here. So the complainant charged that this sort of capturing their facial recognition or capturing their images without any prior informed consent or without informing them violated their fundamental rights. So they refer to Article 8 of UK European Convention on Human Rights, as well as the UK Data Protection Act, because such capturing of image without prior informed consent and then use of that without any prior giving notice is considered as serious violations. So what did the court say? The court said this sort of use breached the Data Protection Act. You need to balance between individual right and community interest. In the sense that you cannot simply say that in the larger interest of the community, I am capturing each and every image, I am comparing that with the internal database, and then identify which images do not match. And then there was also a thing that the software that was used was not free from racial or gender bias. More importantly, that they should have found it evidence that there was no bias from the software. So it was said, halt the temporary use of at least for the time being, and then you need to reintroduce the same thing with proper legal footing, and then with a different train set, or modify the software accordingly. So in some circumstances, they reintroduce the revised facial recognition technology. So the idea is that AI ethics should be promoted as a routine practice, not as a simple afterthought. This is the first case where AI use was challenged under the Human Rights Act. And then, when this is done, it was proved that the Article 8 of ECHR and UK Data Protection Act were violated. So, what we need? We need a holistic commitment to human rights, which ensures that software is free from bias, the respective conventions on human rights and the data protection rights are not violated. And more importantly, such a holistic commitment will also mean that engagement with stakeholders in more than one way. And it is also important that we bring in the human rights expertise to that. While the AI systems can benefit more in terms of efficiency and speed, there is a balance that the algorithmic decision making may go wrong, or may be biased, or may not be fully free from discrimination. So, algorithmic decision must adhere to administrative review principles, which include transparency, effectiveness, proportionality, rationality, and non discrimination. So, the rights of the compliants should ensure that there is a mechanism which addresses their rights, and then they should occur that there should be a specific mechanism available when people find that their rights are being violated. So, human right due diligence should be made part of this exercise. The Big Brother Watch and NGO filed something in July 22, and then it filed to the British Information Commissioner, who is the Commissioner, Information Commissioner for Right Information. It said facial recognition technology has been used in certain circumstances without proper legal vetting or without proper permission. So it sued that this breaches data protection and privacy rights. So the effective government mechanism should be built not as afterthought, but as part of the routine development and then initialization and installation process. And then there should also be an effective remedy mechanism available so that human rights and ethical principles have a real impact and are not violated. And then there is a need for standard bodies that will set the standards for human rights related AI systems so that they do not violate human rights. And more importantly, business should also work with the public authorities and then human rights advocates in them. The harms that could result from the malfunctioning of the AI systems, or without any intention to malfunctioning, the AI system might have harmed certain people. So these things should be taken into account. So the standard setting for AI rights, AI's human rights violation should be made as a part of the regular routine AI audit. So we need to understand the human rights. We need to bring in explainability, transparency. We need to put human rights in the code. And then we need to also link that with other data rights like access to data, privacy rights and all. So we need to build expertise in human rights at different levels for different purposes. And then there are a good number of recommendations from UN and then from various other national human rights bodies, also from different civil society actors in this. But cross-cutting regulation will be required when AI systems are being deployed on a massive scale. This is a real challenge, particularly when human rights can be impacted by AI deployment across sectors in different purposes for different contexts, where facial recognition technology, biometric technology, AI mapping humans' behavior on a continuous basis, getting linked up with datafication data technologies means that human movement and behavior are monitored on a continuous basis. So we need to look at the cross-cutting regulation for AI violating human rights in more than one way. So human rights bodies also need some capacity building. They also need the adequate resources in terms of finance and human resources. And then benefit AI development that respects and honors human rights, that promotes human rights should be made part of it. And then globally, there should be a human rights understanding, harmonize such understanding that minimum standards are set, articles, the relevant articles are interpreted in an unambiguous way, and then certain good practices are identified and then promoted. And more importantly, new norms need to be developed. New risks, if they're identified, new norms would be developed into actionable guidelines and then actionable points. If necessary, the existing Human Rights Act need to be reformed or revised, or a new act may be made part of that among various acts where there is a good scope for AI human rights being controlled. And multi-stakeholder forum or stakeholder engagement continuous basis will be a good opportunity to do that. UN alignment with human rights is something which UN has been trying to advocate for years, of course with some success. So basically when we say AI and human rights, we do not talk in terms of negative impacts alone, we talk in terms of a proactive idea, and more importantly we ensure that AI does not violate human rights either by default or by accident. So taking these things into perspective, there is a good need for understanding human rights in the context of AI so that we know that AI does not end up in harming or negating human rights. In the next class, we will look into AI and legal education. This is session 34. Because AI as is impacting in other sectors, is also impacting huge way in legal education as well. So that will be the focus of the next class. Thank you.